And good afternoon and welcome to the latest in the DisinfoLab series of webinars. First of all, I'd like to thank the European External Action Service for their support of this webinar. For your information, this webinar is recorded and the recording will be available on our YouTube channel shortly. And you can also find all of our previous webinars on our YouTube channel. For the questions and answers and polls, we use Slido. You can access Slido via slido.com, or you can use the Zoom, or you can use the QR code that's on the screen now. We'd like you to start by answering two small polls, asking where you're joining from and what sector that you represent. During the course of the event, you can submit questions in Slido, and we'll come back to them after the presentation. For those of you who aren't familiar with EU DisinfoLab, we are a non-for-profit organization gathering knowledge and expertise on disinformation in Europe. We organize these seminars to give a voice to experts in our amazing community, to help sharing knowledge and to raise awareness around the great work that is being done by many organizations in this field. The topic today is the options available to media companies when their web domains are spoofed. There will be a document on our website shortly that summarizes the presentation that I'm going to give now. We're delighted to have Polina joining us today to give a perspective from the domain name industry. Polina is the policy director at the Council of European National Top-Level Domain Registries, where she leads policy work and liaises with governments, institutions, and other organizations in the internet ecosystem. She holds an LLM in international human rights law and intellectual property rights law, and is deeply interested in interactions between technology and fundamental rights and the freedoms of the digital age. So I will start off by giving an overview of the options available when domains are spoofed, and Polina will give a reply, and then we'll go for the questions. So the problem that we see is that disinformation networks register domain names that are the same as or confusingly similar to the domain names of legitimate media outlets. The contents of the legitimate media outlet's website are then copied and hosted at that domain. So one example is that the French news outlet Le Parisien saw leparisien.re being set up and a copy of their website being hosted at that address. This allowed the disinformation network to post false articles that looked like they were coming from Le Parisien, and allowed them to spread the disinformation via social media. I'd like to also make a disclaimer. What this seminar is doing is giving an overview of the options available. There is a tremendous amount of debate about the speed, proportionality, and effectiveness of the tools that I'm going to describe. Depending on the commentator, the options available are too fast, or they're too slow, they're too lenient, or they're too strict, or they're biased to the complainant, or biased to the registrant. This is a healthy debate, but nothing that I say should be understood as anything other than a description of what's available and not an endorsement. So when a news outlet like Le Parisien sees their domain being spoofed, the first thing that they should do is check to see if the three key criteria are being fulfilled that indicates a problematic and actionable abuse of their domain. The first is whether the domain name that has been registered is confusingly similar or identical to their registered trademark. So in the case of Le Parisien, it was obvious that leparisien.re was confusingly similar to leparisien.fr. Secondly, that the registrant has no rights or legitimate interests in the domain name. That might seem obvious, but sometimes it isn't. For example, there are newspapers called The Mirror, The Times, etc. But a mirror shop might have a legitimate interest in having a domain name containing the word mirror. So it's not automatic that because somebody has a similar name to yours, that they don't have a legitimate reason for having that name. And the third characteristic is that the domain name has been registered and is being used in bad faith. For example, if in Le Parisien's case, you could see the bad faith because they weren't just copying the name, but they were also copying the whole website of Le Parisien. And then once you've established that the criteria are being fulfilled, you then collect all of the evidence that you can that points to this, such as trademark documentation, screenshots, etc. The next thing that you do is you work out whether the domain name, the abusive domain name, is a generic global top-level domain or a country code top-level domain. A country code top-level domain has 2 letters after the dot, such as .be, .fr, and so on. And all of the others are generic top-level domains. This is important because fundamentally the regulation of generic top-level domains has been organized on a global level, whereas country code top-level domains have been designed with national characteristics being taken into account. Country code top-level domains are therefore somewhat more complicated when they're being abused because they vary so much from country to country. A database of country code top-level domains and their dispute resolution procedures is accessible on the World Intellectual Property Organization website. Most of them use a standard dispute resolution procedure called the Uniform Dispute Resolution Procedure, UDRP, or a national variant of the UDRP. So an example of a variant would be, whereas UDRP requires proof that the registration and use of the domain name was in bad faith, the Australian rules, for example, require either the registration or the use to be bad faith, and not necessarily both. The whole purpose of UDRP and UDRP variant procedures is to be clear, predictable, and user-friendly. The procedure normally takes a maximum of 60 days. The list of UDRP dispute resolution providers is available from the Internet Corporation for Assigned Names and Numbers, ICANN. And ICANN provides some really, really clear information on what UDRP is, how it works, templates for making complaints, and really make the process as easy as possible. There are, in this environment, always exceptions. So the country code top-level domain, PW, also allows a more rapid procedure called URS to be allowed. And .us also allows a variant of URS to be allowed. However, some country code top-level domains have no dispute resolution policy at all, meaning that national courts are the only option for asserting your rights. So what does this look like in practice? Well, as mentioned, Le Parisien was impersonated by leparisien.re, which was registered in December 2023. This was registered by the AFNIC registry, which is the French National Registry. Le Parisien launched a case using the French UDRP variant procedure also in December 2023, using AFNIC's online tool and providing the necessary documentation. And the following month, in January 2024, the domain name was transferred back to Le Parisien after a default appeals process. So if it's a generic top-level domain and not a country code top-level domain, things are much more straightforward. In that case, the uniform dispute resolution procedure is always available. You choose an arbitration panel as approved by ICANN, and the procedure, as I said, is quite straightforward. For some generic top-level domains, particularly those set up after June 2013, there is another procedure also available as an alternative to UDRP, and this is the Uniform Rapid Suspension Procedure. This is designed to be as quick and cheap as possible, and available in cases that are really clear-cut. So the procedure can normally takes less than 21 days and is possible for all generic top-level domains apart from .com, .net, .org, .int, .aero, and a few others. Basically, you can use this if all of your documentation is clear and unequivocal, and a URS panel can make a decision with confidence that the abuse has taken place. In the case of URS, the domain is suspended rather than transferred back to the rightful owner. So it's not as final as UDRP. There are a variety of other options available for asserting rights in this area. The company that runs .org set up an organization called NetBeacon, which allows reports to be submitted via the NetBeacon tool in cases of phishing, malware, spam, and botnets. You can also You can also complain rather than complaining via UDRP or URS. If your case is straightforward, you can also contact the registrar of the domain name, and the NetBeacon online complaint tool can be used to identify GTLD registrars. You can also use a notice and takedown procedure. If your website has been copied, you can go to the company that's hosting the website and submit a notice that the content has been copied and is being used illegitimately, and request deletion of the content. There are a lot of companies that offer to do this on behalf of rights owners, but it's quite straightforward to do that directly. You can check. You can simply do an online search for sites that allow you to check who the hoster is of a particular domain. Look up the abuse email address of the company that's doing the hosting, and the most straightforward thing is to find a standard DMCA notice form and submit this to the hosting company. This is designed for the US legal environment, but would also work in the EU. And you send your complaint to the abuse address of the hosting company. This approach can be effective, but it depends a little bit on the jurisdiction of the hosting provider And it also depends on if the entity that's abusing the content is motivated enough to simply move the content to another jurisdiction. So that is a quick tour of the dispute resolution options available. I'll pass the floor to Polina to give some perspective from the Country Code Top-Level Domain Association's perspective and add anything that I might have missed. Over to you, Polina.
Thank you, Joe. And also good afternoon from my side as well to everyone who has joined us today. So first of all, I would like to thank Joe and EU DisinfoLab for allowing me to offer you a few insights and provide an opportunity for me to say a few words about rights protection online, and specifically when it involves domain names and ccTLD registries. So yeah, I will go straight into a couple of clarifications, or more just, it's not even clarifications, but more a few words that I like to highlight from Joe's introduction. In general, I would like to say that the guide that will be available after this webinar for everyone to read up about alternative dispute resolution procedures available for rights holders across domain name space is yeah, a very good resource that I hope yeah, you'll be able to use more and refer to more often. So thank you, Joe, for compiling that. So first, yeah, for a couple of remarks that I prepared for you today to give a bit more insight on the peculiarities of a DNS or domain name system, and when it comes to rights protection. So first of all, I would like to highlight, and Joe already said that, but I would like to a little bit deep dive into this point, is important to remember that domain name is not a website. So it is a technical identifier, and yeah, it's a foundational piece of internet infrastructure that directs humans and computers. So humans via domain names, and of course computers with the mapping of domain name to an IP address to the desired online resource. So this could be a website, it could also be an email, a message, an application, etc. So domain name registries themselves, who are managing the top-level domains and organizing the domain name registration process, they do not host nor transmit any content via their infrastructure. So it is also important to note that to effectively take down harmful content, and of course when it also comes to disinformation, rights holders and authorities of course need to keep in mind that by domain name level action, the content is not taken down offline. And yeah, so there needs to be usually also a parallel process for a content removal that Joe also highlighted through a notice to the hosting company, for example. And at the time of the registration of a domain name, it is also often not possible to judge if that domain name is going to be used for abusive purposes. So a lot of times it's also not possible to preemptively block registrations of domain names that can include protected terms such as trademarks, because domain names are a limited resource, and there could be an equivalent trademark with a protected term that can be in hundreds and thousands, but there can only be one domain name. So for these reasons, of course, we have the alternative dispute resolution procedures established when multiple legitimate interests could be weighed over, and there is a way to dispute an ownership of a domain name. So the subsequent use of a domain name, including by connecting it to a different service, like for example, hosting a Doppelganger content, or using that domain name for phishing campaigns, or in general to create consumer or user confusion, then that subsequent use of a domain name after its registration determines if such domain name may be used in bad faith that Joe was referring to. So of course, in the context of Doppelganger sites, it is the user confusion that can be used as a justification to argue that the domain name and its subsequent use has been bad faith. So the alternative dispute resolution procedures that Joe also mentioned that are available across GTOD and CCTOD space. So they have been historically developed to address domain name ownership disputes in relatively cost-efficient and speedy way, of course, in comparison to the court proceedings. So as already mentioned, since the domain name is a technical resource, there might be a competing interest for a domain name for its character string, so its name, that includes protected terms. And as Joe already pointed out, there are differences how the ADR, or alternative dispute resolution procedures, are organized across CCTOD community. So the country codes, the country code top level domain names such as BE, FR, .D, and others. But I would actually like to highlight that these differences in the ADR procedures that are established within CCTODs can also be actually used in benefit for rights holders. So UDRP is quite, it's a standardized, it's a uniform procedure, but it's quite rigid. So it's impossible to change it for a GTOD. But in CCTOD space, since UDRP is not mandatory, and CCTODs may use it, but they also may create their own ADR procedures, and they can actually take into account the local and regional context, and, for example, include also additional protected rights in addition to trademarks. And UDRP only recognizes trademarks as the protected term. But in CCTOD environment, these protected terms that can be invoked in ADR procedures can also be other IPRs, like geographical indications, for example, but also sometimes company names, brand names, and they don't need to be registered as trademarks. So this could actually offer more opportunities to protect your rights online, and specifically invoke other legitimate interests for dispute in the ownership of the existing domain names. So I would like to, of course, encourage rights holders to explore this, and to be able to also invoke other interests when it comes to ADR procedures available across CCTOD community. And there are also additional ways to protect your brand and your company name online, and also do it preemptively, so before resorting to the ADR procedures. So because, again, I have to repeat myself, domain names are limited technical resource, and they are also registered on a first come, first served basis, mostly due to its technical limitation, but also to allow domain names to be available for all legitimate users without discrimination. So rights holders are also encouraged, and they have an opportunity to register preemptively domain names across different TLDs as a defense mechanism. And some registries and also registrars also offer a so-called brand protection services, like additional services such as domain blocking for registration, meaning that when domain names are not actually registered, but a registrar might that offers domain name registration across different TLD portfolios might actually offer this opportunity that brand names can be blocked for registration. It is quite a complex area, of course, due to many legal and technical complications. So it's not a uniform practice, but it can be utilized for brand protection. And SIDN, the registry for .nl, for example, they offer a so-called brand guard service, which is a monitoring service that flags typo squats and brand name abuses to rights holders, and also gives an option for an immediate legal action when these notifications are provided to a rights holder. And so again, there are these additional opportunities available online, and for the domain name blocking that I mentioned. So it's as a brand protection service. So it prevents registration, but of course, if there is a competing interest for a similar domain name, because there is an equivalent trademark or other interest, then of course that competing illegitimate user might register a domain name, even if it's on the blocked list, but at least it might hinder malicious actors, since there needs to be some type of proof why the potential rights holder can register such a domain name. And of course, there are also other practices in place across CCTODs. I would also like to mention, for example, Punctum Decay, which is the .decay registry, and they have a special procedure to suspend typo squatting domain names if a number of conditions are met, like, for example, an existence of a website that exploits the confusion of internet users. So it's almost, I think, an end of my intervention. So I would also, as the last point, would like to highlight that there is also a possibility to assess if involvement of a competent authority can be helpful for the action at the domain name level, but also at level of other internet and digital services, such as like ISPs or hosting service providers, like Joe mentioned. And there was a recent case in the US just a few weeks ago, or a week ago, where there was some media reports of action in the US by US authorities that seized 32 domain names used for disinformation based on a court order. So so there is also an opportunity to act by law enforcement authorities specifically. And here I would also like to mention that Nominet, a .uk registry, they have also a special collaboration procedure with the IP crime unit in the police that processes and coordinates requests for Nominet relating to IP infringements. So so there is also an opportunity to coordinate actions via national competent authorities. So with that, I would like to give the floor back to Joe, and I'm looking forward to any questions that you may have. And thank you very much once again for having me today.
Thanks, Polina. I'll take one of the questions from Slido. Just to remind participants that they need to use Slido to ask questions rather than the Zoom option. The first question on the list is, can you give some examples of dispute resolution decisions that caused controversy? I'm not sure if you've got a favorite one, Polina. The one that I always think of is the WIPO arbitration panel's decision on WalmartSucks.com. The panel, somebody registered WalmartSucks.com. Walmart is a big US retail chain. Somebody registered Walmart Sucks because they didn't like Walmart, and Walmart took an arbitration case arguing that it was confusingly similar to Walmart.com, and the arbitration panel ruled in favor of Walmart, confirming that consumers might get confused and think Walmart Sucks was actually Walmart. There was a similar case in the UK with Ryanair Sucks.something.uk, and also the decision went against the registrant of the domain. This time because there were ads on the website that was critical of Ryanair, and the ruling was that because somebody was making a trivial amount of money out of the website, they were making a trivial amount of money out of the domain name, and therefore Ryanair Sucks was transferred to Ryanair. So it's impossible to build something that nobody can do badly, not taking a position on whether these decisions were bad or not. I'm not sure if you've got any favorite cases, Polina.
Yeah, very good question. In general, of course, yeah, I'm mostly interested in successful cases because it also shows that the existing procedures are working and can be used for legitimate purposes. But maybe one of the also another controversial cases that they were already a few years old, but there's also a France.com case where even though France in English as a name is not a protected term, right? So because the French Republic and its official name is different, but it was used as a the justification to transfer the domain name that was owned and operated for sort of as a tribute to French culture by a private individual in the US, and it was actually transferred to French state and French authorities to promote tourism to France. And it was quite an interesting case in terms of judging what is how far the sovereignty of a state goes online, and whether unofficial names of the state can be used as a justification to transfer the domain name ownership to the state. And so I think it also quite an interesting case where there was no bad faith use of a domain name, yet it was transferred to the French authorities. So that's so we could argue that it might be slightly controversial, but yeah, I think this is something that came to my mind. But other than that, can't think of anything else.
Okay, a fairly straightforward question on the cost of these processes. If memory serves me right, UDRP for a single domain name is about $1,500, and URS is about $250. And then, but if you have if you've got a registrant with multiple domain names abusing your registration, your rights, you can package them all up and the cost is less. I'm not sure if you've got any more precise information, Polina.
No, unfortunately, no, I don't have any additional information on that. Of course, in the ccTLD world, it varies depending also on the different provider used, and if there's an arbitration panel, of there are multiple stages of dispute resolution. So so it varies, but I unfortunately cannot comment on UDRP.
But basically, I think 1,500 to 2,500 is the ballpark. Do different policy approaches adopted by registries lead to different outcomes in the real world? I know from memory, I know that the Irish registry, at least historically, wanted to avoid problems arising. So they had a process of checking everybody's documentation before awarding the domain. And the UK had the opposite approach, where they only investigated when there was a complaint. And that led to significantly higher overheads for the Irish registry compared with the UK registry, which led to the cost of a .ie being something like €50 and a .uk being about 10 times less. Both approaches obviously have merits and have different priorities, but the real world outcome in that case, at least in terms of price, was quite significant. Do you have any thing to add, Polina?
Yeah, it's a very interesting question. but in general, also as highlighted in my remarks, actually the differences in policies might and most of the time allow for more flexibility, in terms of course, that policy establishment and but also when it comes to rights protection. So I wouldn't say that I will have a concrete case when, for example, there was an equal or similar domain name across different ADRs, and if they had a different outcome because of the different policy. But as I've highlighted, actually CCTOD ADR procedures have more opportunities for different rights to be invoked in these ADR procedures that go beyond just trademark protection. So would like to once again highlight that there is a way to also invoke like it doesn't need to be a protected trademark if it's a brand name or a company name. It might be also already a legitimate basis to initiate an ADR procedure in a specific CCTOD. It could be also other IPRs. So and that we see already the difference between GTODs and CCTODs, specifically when it comes to the protection of geographical indications. We actually have that data available where because geographical indication is not considered to be a trademark or a protected right globally, then it was impossible to for example, dispute Gorgonzola or one of those protected geographical indications terms in GTOD space, but they are protected in Europe, and they were also they are recognized as a legitimate right that can be invoked in ADR procedures within CCTODs, like .fr, for example, and others. And there we saw that it was possible to invoke that protected right and get the ownership of the domain name to be transferred to the legitimate owner of the geographical indication. So there we see that clear division and different approach towards protected right. So I think that comes to my mind for this question.
Great, thank you very much. A question that has bothered me for some time, which is why the uniform rapid suspension isn't used in cases more often or at all in cases in doppelganger cases, when it seems if you were designing something, and we have a blog post on our website, it basically says if it walks like a duck and quacks like a duck, we should consider it to be a duck. And if it walks like a doppelganger and talks like a doppelganger, it's probably a doppelganger. So I can't imagine anything being designed more perfectly to suit the circumstances of doppelganger than uniform rapid suspension. And yet it doesn't seem to have been found to be the solution. I would be curious to know if you've got any opinions. So over to you, Polina.
Yeah, also very interesting question. Unfortunately, I do not know for sure. Again, I have to stress that the UDRP and URS are quite GTOD specific. So of course, I just simply do not have that experience from the CCTOD perspective. But as I understand, URS is primarily available for so-called new GTODs. So the TODs that were basically became more available for registration after 2012, if I believe, but last round when the number of GTODs was expanded. So the legacy GTODs like .com, .org, and others are excluded from URS. And in general, the new GTOD space, so the expanded TOD space, actually did not pick up on the use so much as it was expected. So perhaps it's also related to perhaps the market share and the fact that yeah, that most of the cases is easier, or I wouldn't say easier, but it's just probably more efficient to deal with UDRP because it covers more GTO, I mean, it covers all GTLDs and of course, yeah, including legacy GTLDs. So perhaps, yeah, perhaps there's a justification there. But yeah, unfortunately, I don't know, have a clear answer to this. Yeah, I think I agree with Joe that clear-cut Doppelganger cases should, of course, yeah, be a quite the appropriate venue for EEAS to decide on. But unfortunately, I cannot comment.
Okay, that's for the record. I've asked everybody that I can find versions of this question, and have been unable to find anybody with even a theory as regards why this isn't the case. A simpler question: the proportion of UDRP cases that are successful. Do you have an idea, Polina?
No, I don't have an exact figure.
From memory, I think it's something like 96 to 97%. I think if somebody's prepared to invest the money in taking a case, I think they're probably quite confident that they're not throwing away $1,000 or $2,000 for nothing. So it might seem like a very high proportion, but in context, it seems reasonably logical. If I could throw in a question, Polina, the internet governance world is quite active, and everything's constantly being reviewed and questioned and updated. Do you see any discussions on a European or on a global level as regards these problems and new approaches, new solutions? Any learnings that have been done, or any decisions that are going to be made in the near future?
Thanks, Joe, for an additional question. So yeah, so I guess I have to use again my favorite example because we've worked quite a bit on those questions in the recent past. So you might know that there was a revision of geographical indications protection in the EU, both for agricultural products, but also for craft and industrial products that are now considered to be protected geographical indication, similarly to already, of course, existing and well-known agricultural GIs like champagne and yeah, gorgonzola that I mentioned, and feta cheese and others. So and specifically that EU reform also had quite an attention also on domain name, into domain name space as well, and recognized that there is a need to protect geographical indications also within the domain name space, and specifically yeah, the tension with UDRP when it comes to the fact that it doesn't recognize geographical indications as protected and invocable, right? At least in Europe, it's been recognized that the ADR procedures that are in place for country code top-level domain registries must recognize geographical indications as a protected right. So that definitely harmonized that area, and also put forward an idea that more protected rights should be included in the in the alternative dispute resolution procedures if they are in place. And of course, yes, the traditional court proceedings are always there, and of course they are also the final, let's say, word in the domain name disputes as well. So even if the UDRP or ADR decides to transfer the domain name, and if an opposing party is wants to dispute it, the court proceedings are still, of course, available for those cases as well. But so I think this was one of the, let's say, the latest movements in the area of reforming alternative dispute resolution procedures in domain name space. And I know that the EU is also quite active in bringing that issue to the attention of a global IP community, also within WIPO and these specific global fora when it comes to intellectual property rights protection. So there's definitely some movement there, but it's also, of course, a political question. Geographical indications are primarily, like they're considered to be part of European culture and cultural and gastronomical heritage, and other parts of the world, you might have different ideas for that, but there is the movement. But at least when it comes to European ADR procedures, then geographical indications are now also recognized. So so I think from my side, this is what I would highlight as the latest one, and there might be also other areas for discussion that could drive that type of rights protection forward. But it's a moving field. It's a slow moving field, because it's of course when it comes to international cooperation and collaboration, it takes time, and specifically when we talk about global domain name system, it's also a question of multi-stakeholder model, and so different interests and different stakeholders need to be heard and participate in the discussions. So there are movements, and thanks, Joe, also for bringing up the statistic of successful UTRP cases. It really shows that it is a working environment and method to effectively protect rights online. And I would like everyone to encourage everyone to make use of it. These procedures are there in place, and they are relatively successful. Would encourage everyone to try them out and be in touch with authorities, get in touch with registrars and registries. So also to share and raise awareness of the issues. And it's a fast-moving field in terms of bringing new perspectives, but there is a way to change these procedures also on global level.
And just to abuse your time slightly longer, do you see any significant change being brought about in this area as a result of recent EU legislation, like the DSA or like the Network and Information Security legislation, NIS2?
So also very, very good question. For alternative dispute resolution procedures, I don't think so. But I think in general, both DSA and NIS2 are, of course, directed towards increased safety online in different ways. DSA is about content moderation, while NIS2 is about the security of networks. So of course they have completely different purposes, but they contribute to, let's say, a similar overarching goal, which is the increased safety and increased safety and security online. So both are relevant for domain name registries. DSA attempted to change the regulatory environment in the sense to offer more clarity to, of course, to authorities, to the public, but also to the operators themselves, that DNS operators are considered to be intermediaries, so they do play a role in making content available online, while, of course, as I've also already indicated, they do it in a different way than internet service providers or hosting service providers. But nevertheless, DSA clarified that, so considers domain name registries and registrars to be intermediaries for the purposes of DSA. So yeah, so but of course, yeah, due to it's quite how to say it's since domain name actors, they're not really involved with content per se. So for the reasons that domain names really do not host nor transmit any content, they're nevertheless used to navigate towards content that could be harmful and illegal when it comes to DSA. So if there is any action that could be mandated from registries when it comes to tackling the illegal online content, then of course it needs to be based on a clear and proportionate order from the competent authorities or judicial authorities. So so that stays the same, and that was always the case even before DSA clarified that registries can be considered intermediaries. So as technical operators, of course, registries cannot judge if content is illegal, if it's harmful, if it's and if something needs to be done. So they rely on cooperation with authorities and competent authorities to make that assessment of illegality of the content before domain name level action can be taken. So in this sense, DSA didn't change much, but at least it clarified the expectations towards what registries can do. And when it comes to NIS2, this is maybe the link with the let's say content moderation questions. So because of that special role of internet infrastructure actors like domain name registries, and because they cannot judge over legality of content, they can only act within their technical remit when it comes to tackling issues with illegal content. And one of the ways how to do it is upon domain name registration, registries actually collect, or they require collection from registrars, personally identifiable information about the domain name holder. So that's mostly for the reasons of basically because they are in the chain of domain name provision, and even though the registrars are the ones who offer domain names to public and collect the payment data, etc., but they do have to also share some information with the registry who then provides that domain name. So so one of the ways how to tackle harmful content without actually judging over legality of content is to conduct a accuracy check of that identity data when it comes to the domain name holder. So a lot of times malicious actors are of course not interested in providing correct information about their identities. So if there is a complaint about a problematic domain name, then a registry can initiate a so-called verification identity check of the domain name holder. And if domain name holder fails to do so, then the domain name can be suspended or deleted. So so this in a way is became a tool how to act on problematic domain names without judging the legality of the content that is associated with the domain name. So bringing back to the NIS2 actually puts a data accuracy obligation on both registries and registrars to verify the identity of the domain name holders. So so in an attempt to unify that practice across many domain name actors. So and that's also was done and there is a justification in the NIS2 for inclusion of such data accuracy obligation is to basically fight abusive uses of domain names. So we have to, of course, see if this will bear fruit in terms of if there will be less abuse online. But there is that indirect link because in this case, registries will have the obligation to keep accurate domain name registration data. But also, yeah, there is an indirect link with potentially keeping more rogue actors out. But of course, it creates more challenges because personal identifiable information can be stolen, can be sold, to be used by malicious actors, for also domain and registration purposes. So of course, it probably will create new challenges that need to be tackled, but it needs to has that accuracy obligation in place. So we'll see how much it will help with security online.
Thank you very much. That's an interesting tangent to the question of how to deal with inappropriate domain name registration. We're coming towards the end of our time, so I would like to thank you, Polina, for your extensive explanations of very technical topics and very technical legislation. We're very grateful. Thank you to the participants for attending and for their questions. As mentioned, the recording of this webinar and all of our other webinars are on our YouTube channel. The summary of the guide for how to react to abusive domain name registration will be on the EU DisinfoLab website within the next few days. And we'd like to again thank the EEAS for their support of this work. For your reference, the Disinfo annual conference is next month and is filling up. So if you want to attend, please go to our website and find out how. Also, we have a newsletter that is very, very popular. So if you haven't done so already, please subscribe so that you can be aware of new webinars and new developments in the disinformation space. And finally, if you can use Slido to rate this webinar and to suggest topics for future webinars, we would be very grateful. And with that, I say a final thank you to everybody and wish you a good afternoon. Goodbye.